section area of the agenda. We've got information item 14, which is a final ruling by Judge Connolly on the QSA coordinated civil cases, page 79 of your agenda, and presenting is Joanna Smith. Welcome, Joanna.
Tell them what you're doing.
Did you want to move a couple things up?
Thank you. Real quick, I wanted to see if we needed to address the agenda. I think we're discussing. Sorry. Okay. On July 31st, the final statement of decision and 3 judgments were issued by Judge Connolly. The 3 judgments were on the 3 cases that are still comprising the QSA coordinated civil cases. That includes IID versus all interested persons, Power versus IID, and Imperial County versus Metropolitan Water District. So Judge Connolly did issue a separate judgment on each case. In the IID case, with regard to validation, Judge Connolly held that the QSA agreements are legally valid and enforceable. He had 6 bases for this determination in the judgment. IID had the authority. Majority of the members voted. The board acted in compliance with the Brown Act. The action was in compliance with CEQA. And then there were 2 bases, which is the ultra-vires arguments that we've heard about, which is the delegation of authority and then the board acting on the delegation of authority were valid. In those judgments and under the validation statutes, costs are allowed. Judge Connolly did state that costs may be awarded. There's not an award until there's an actual memorandum of costs submitted, and amounts are put on the record, filed with the court, and the court makes a determination. So we're not to that stage yet. The judgment just allows for costs pursuant to the validation statutes. Part of the 2 other cases were petition for writ for CEQA challenges, and both of those petitions were denied. In the cases, there were arguments for attorney's fees. The judge also has not awarded attorney's fees. We're not to that stage yet, but the judge said that he would retain jurisdiction to hear and determine motions for attorney's fees. So unlike the costs, which are automatically allowed under the validation statutes, attorney's fees is under another area of law, and it's questionable. Arguments can be made, motions can be made, and the judge is saying that he'll just retain jurisdiction if such motions are filed. So no awards yet are made. The determination by the final statement of decision by the judge was made after objections were filed by all of the parties to the cases, and those were filed by June 26th. The judge addressed those objections that he found appropriate to address in his final statement of decision. He expanded his decision, and it's now about 100 pages long, but he still took the same position on all the issues as his tentative statement of decision, but he went into greater detail to address those objections. And I'm available for any questions.
Joanna, on the bottom of page 20 of the decision by the judge, it addresses in the footnotes this decision 141 that's been quite talked about. Could you share with the board and the public here and the television camera what information's and how that information is important?
So what's referred to as Decision 141 or 141 or Order 141, it's called by the court Contested Matter 141. And what occurred in the first trial case was that as contested matters came up or issues of dispute, Judge Candy would address them each individually, and so each one was assigned a number. So contested matter number 141 is specific to the 141st contested matter that Judge Candy addressed. It was an issue that was raised in a summary judgment motion by IID, which essentially is a motion that is made to say all these facts are agreed upon, Judge, and based on all these facts, no one disputes the facts, you comply the law, and you can make a decision now instead of having to take this issue to trial. And so what IID was saying was that there were not disputed facts with regard to certain assertions that were made that allocation had to occur before IID could enter into the QSA agreements, and that was the issue in contested matter 141. Judge Candy denied the motion. What he said was that there wasn't sufficient information to make a ruling at that time, that there were potentially disputed facts. There just wasn't enough information to truly say that there were undisputed facts. And so it needed to get kicked to trial so that more information could be provided and the decision could be made at trial. In Judge Candy's final statement of decision on page 47, he said the water did not need to be allocated prior to IID entering into the QSA agreements. So that matter was adjudicated. It just was not adjudicated. It was not finally decided in contested matter 141. It was finally decided at trial. And Judge Candy's decision on that matter was final. It was not appealed. And so Judge Connolly here is saying that that decision, that finding is final and was final by Judge Candy, and it's binding upon Judge Connolly in the subsequent trial.
Thank you, Joanna, for that. Board, do you have any questions or comments?
Yeah, I do. In regards to 141, but as more a matter of allocation, it's been brought up that people don't want to sign up for allocation. I think currently we're at 25 or 30% of the farmers have signed up for allocation through the paperwork, and they're saying if they sign up, then they're agreeing to the QSA or some sort of limit in the future. And I guess if you could just speak to that as far as does this ruling change anything as far as the validity of the QSA, and are they liable for anything the QSA can create down the road if they sign up for allocation?
No. Essentially, the argument that was made was purely that a procedural step was necessary by IID.
Okay.
And actually, the allocation, the equitable distribution plan that we adopted is under one section of the water code. The argument that was made in the trial was that there were 3 different sections of the water code that required allocation. And under any of those sections, allocation procedurally was required to be done before the QSA was entered into. And the judge said on all 3 areas of allocation, that was not a requirement before IID entered into the QSA. It has nothing to do with the allocation now, and this contested matter 141 has nothing to do with the validation of the QSA agreements or the term of the QSA or being locked in under the QSA. It's a separate program under the water code that allows for equitable distribution.
Okay.
Any other comments or questions for Joanna, Board? Any comments or questions from the audience?
Again, Tony Ramos of Central Resident. You know, I see the IID emblem or logo, and it says a century of service. When the IID first started back then, it wasn't near the issue that we have today, you know. And I know those people that started the century then are probably living now. My point is that the QSA that Judge Connolly backed up, that validated, provides peace in the river and reinforces the water rights, and we don't transfer any more water than conserved water, if I'm not mistaken. Now, the people that were suing the IID, along with Judge Wiener, they're going to pay him a certain amount of money to apparently hear the case. They would have in a step of your hands, or however you want to call it, they would have collected that money if Judge Wiener would have allowed it. And yet, here's a judge has no really how would I say, is very fair and balanced, and he's saying, you, the people that sued the IID, now can collect from them. People like, they say, Barioni and Crush, you can sue the IID. No, I'm sorry. The Baronian Crush. I'm trying to read under my hat here. The Baronian Crush, County of Imperial, Cuadro del Mar, Imperial County Air Pollution District, Ron Langgruber, Morgan Holtz parties, which includes Walter Holtz, Tony Holtz, Mike W. Morgan, John J. Elmore, Richard Elmore, Gary Foster, and Rodney Foster, and Protect Our Water Environment Rights. Now, the IID can come back and collect court costs and attorney fees, if I'm not mistaken. That's what he said. No, this young lady says no, that attorney fees are questionable, that they're neither here nor there. But to me, they can collect attorney fees, especially court costs. The victims in this case were City of Escondido, Coachella Valley Water District, Imperial IID, San Diego Water Authority, the State of California, by and through the Department of Water Resources, Department of Fish and Game, and the Vista Irrigation District. Now, to me, what's fair is fair. Everybody put their 2 bits in, and I remember back in 2003 when me and Bruce were probably sitting here, waiting to see whether QSA, Mr. Kuhn passed it, yet he wrote a statement that said he didn't know the whole truth about the matter, and that's his prerogative. I'm not questioning that. But trying to blame the attorneys that didn't give you the information for passing it back then, and coming back and say, well, that's the reason I passed it then, but I'm for it now, or against it now, to me, questions, what kind of leaders we have. And I ask you, what kind of leaders are you that you would sit there and allow these people to sue you and not collect from them? You paid a company to represent you, and I heard they spend probably over $10 million in representing you. They should be allowed to collect those fees. They shouldn't be up to the board to decide for them not to. And when 80% of a server online says that they agree with a QSA and with Judge Connolly, people, open your eyes. Don't blame me for bringing this information forward. Listen to the facts. I know that Mr. Desidder has made a comment every now and then that there's someone talking up here at the podium, and it might be me trying to cut back or trying to blame somebody else, but no one's being to blame here. The real issues are what you're going to decide and who sued the district. I went to the Board of Supervisors about a month ago, and I found out that the county has paid Rossman $6 million, him and another company, almost $6 million in trying to defeat the QSA. Now what are they going to do? And that's taxpayers' money. $6 million could probably go a long ways in a county coffers to do what's good for the people, as you normally have always been a champion, the people that really need it. So all I'm trying to tell you is that let's go forward. Let's not try to find a reason to put Judge Connolly or anybody else on the spot. He decided, he ordered it. Let's work with this. And the final thing to me is that the QSA is valid. It's there. Again, it provides peace in the river for us. It defends our water rights. And to me, we should defend it and not try to look for loopholes or questions or blame other people for what's happening. Thank you very much.
Yeah, thank you, Mr. Rossman. Mr. Ramos, excuse me. Any other comments from the public? Board, any comments?
I have one. I think it's important, now that QSA is behind us, that we keep moving forward. I, for one, wasn't here when the QSA was enacted in 2003, but now that I'm on the board, I find myself being forced in a position to implement it and to work within some of the constraints that it gives us. We as a board have put a lot of work into this, analyzing the long-term pros and cons of the QSA. I think we're going to continue to look forward and seeing how we can work with the QSA, but also with the farm community and support farming. I think it's important that we do that going forward for the future of the valley and for the future of the river and for the future of the West. I mean, we're vital to a lot of pieces of the pie here in the west coast of California, the Yuma area, Palo Verde Valley. And the QSA impacts a lot of that throughout the region. So now that we know that it's been finalized, we're working forward on how to implement some of the steps and hold other people accountable. They've always held us accountable, but now it's holding the state accountable on the Salton Sea. It's holding the other parties accountable on a lot of the things that they've said that they're going to do. So I'm sure it'll come back again as our pilot programs, the pilot gets dropped and we start doing on-farm conservation for the future. The apportionment and working out the bugs there, it could become very important in the near future that we show that we're conserving water effectively and efficiently, so we can show that other regions that we're doing our part. When we are the largest water purveyor on the Colorado River. So a lot of eyes are on the IID, on our public, on our users, and this board is up to the task, I believe, to do what we can to protect the IID. So thank you.
Thank you, Director Benson. Any other comments from the board? Okay, not seeing any. We'll move on to information item 15, a discussion regarding Veterans Preference Policy, page 80 of the agenda. And presenting today will be Director Bruce Kuhn.
Well, we don't have to take a lot of time on this. Dan, I know that the federal government has a veterans preference. I know the state of California has a veterans preference. I believe the county of Imperial has a veterans preference.
They do,
and we don't.
They do.
Now, I'm not so jazzed that I think that it should be disproportionately given to them. But if I'm trying to think, the state or county's 5 points.
It's 5%.
5%.
Yes, sir.
Okay. So, I mean, it's kind of a tiebreaker, basically. I mean, if you had two people that qualified the same, then if you were a veteran, then you were hired on a veteran's preference.
Yes, sir.
Okay. If the rest of this board is okay with something like that, I would really like to see something like that implemented. We've got as the young man that called me, they're coming back. Some of them are wounded, some of them aren't, but they've done what they said they would do. They've served this country, and that's got to be worth something. It just has to be worth something. And I would really like for this board to entertain, when this is brought back, to approve something like this. And I guess you could write something up, couldn't you? And
We certainly could.
Get it done?
The only thing I would want to have some time to check is to make sure that we can. The only, because
Yes.
the county has it. I just don't know if that's somehow tied to veteran funding or federal funding. So that we just want to do a little due diligence.
And I think we would be wise to do so. And I thank you. Thank the board.
Any other comments, board?
Yeah, several years ago.
Yes, sir.
Several years ago, our hiring practice was under fire.
Yes.
We're up from underneath that now.
Yes, sir. We
I
were.
would like to have just kind of follow up and see how we're hanging with the dictates that came down on us. And see
We can do
whether
some follow-up on that. I'd be happy to.
Okay.
And, oh, good.
Yeah, the whole board would appreciate that update.
Okay.
'Cause we do hear about that.
You betcha.
And I do want you people, I don't want to take 100% credit for bringing this forward. Johnny Hernandez stopped me out here 2 weeks ago, and he said, do we have a veteran's preference? And I said, I don't think we do. He said, well, we need one. And so he kind of planted a seed, and so, okay. So he's as much if this does happen, he's as much credit as I am, okay?
Thank you.
Thank you, Mr. DeVoy. Next up is information item 16, monthly update on Colorado River issues, page 81 of your agenda. Presenting is Tina Shields, and I've been asked to follow up this item with a couple of other water items that play off well from this, and that'll be items 23 and 24, review the 2014 calendar year fallowing program, and then consider the fallowing IID-owned Western farmlands conservation. So we'll be moving this agenda around a little bit at a request, and I think the flow of conversation and the subject matter will work out appropriately. Ms. Shields?
Hi, I'm here today to give you an update on some of the issues we've talked about in the past. You'll see some similar graphs, and then just to talk a little bit about some new processes. I'm going to talk about the hydrology, but today I'm going to talk to it about one of the venues that occurs annually on the Colorado River, and that's the creation of an annual operating plan. This is an annual process that's intended to document the existing year's water operation conditions as well as projecting what might occur the next year. It ultimately is comprised of a series of meetings and webinars with the basin state water users and stakeholders, and then the Secretary of the Interior does sign off on this document ideally before the next calendar year starts. So this is an ongoing process. There's been 2 meetings, and it's in the process of being finalized next month at the Colorado River Basin States Technical Committee meetings. I've put on here web links that are not in your agenda so that if folks want to go and get more information, this is a good place to find everything in one location. So one of the main purposes of this process is to document the hydrology and the reservoir operations, or at least the range of operations that may occur the following year. This graph you've seen before. The primary takeaway from this is the hydrology is not getting any better. It's not been good, and it's declining even further. The reservoirs are continuing to drop. One of the questions I had when I gave this update to the WCAB last month was the line at the bottom that says, what's total system storage and how can it be 51% when Powell and Meade are 47%? So I've added a graph here on the right. You'll see some of the different reservoir storage that occurs in the upper basin. There's different reservoirs that obviously have higher volumes of water in them to skew that percentage above what you see in Lake Powell. On the left, just teeing up some of the discussions that are going to be occurring, and I'll focus on later on in my presentation, is just a summary chart of the unregulated inflow into Lake Powell, which is the upper basin reservoir. And the key takeaway from this graph is that it's not looking good. You see all those percentages are below 50% and in many cases below 40%. And so water supply conditions and snowpacks and rainfall is not doing any improvements, and we're not seeing things turn around in the midst of a drought. It's just ongoing and getting worse. One of the things the operating plan documents is 3 different scenarios. Basically, it's best case, worst case, and most likely, which is in the middle. What we've seen documented in the annual operating plan from last year was the most probable case of an inflow for Lake Powell of 8.85 million acre feet. That was projecting things weren't great. It was only 82% of normal. But the reality check you'll see in the right-hand column, which is that what has actually occurred in that time period is only 41% of average. So it's 50% less than what they projected. So you can see things are just continuing to decline from a water supply perspective. You've seen this graph before. It's just an operational table that talks about trigger points. I think I may have mentioned before, every year on a water year, which starts in October, there's a release schedule that defines the following year the volumes of water that are transferred from Lake Powell into Lake Meade. On a normal year, this is 7.5 million acre feet, which is the lower basin entitlements, plus half of the Mexico apportionment. And historically, you see here the patterns of those releases. Pretty much the straight lines across is the 8.23 million acre foot release. That's a normal release. You'll see in the years where we've had really good hydrology, there's been supplemental waters and reservoir balancing. We saw that in 2011 and 2012, where the volume of water in Lake Powell was greater than Meade, so they sent some extra water our way. What you don't see very often is flows below that 8.23 million acre foot, except back in the 1960s when they were filling Lake Powell. But this is the circumstance we're looking at. Right now we're on the cusp of deciding whether or not the release for the water year for 2014 is going to be the normal 8.23 or a reduced release of about 3/4 million acre feet less than might normally occur. So this is just a bar chart showing in the months what that variability might be over the next 12-month period. The complexity we're in right now is based on some of the coordinated operating plans that were developed in the last 5 or 6 years anticipating shortages. They'd make this decision based on a modeling forecast, and it's based on what's called a 24-month forecast. They look ahead for 2 years and they take all of the uses and all the forecasted hydrology, throw it into the model, and they do a projection of what the Lake Powell Reservoir elevation will be on January 1st. Right now, we're within 0.03 feet of the trigger point for a lower release. So things were looking in July not so good, but the month before it was slightly over. So we're now basically down to 0.03 of a foot on a computer model projection. It doesn't matter what actually happens on January 1st. If we have all kinds of rainstorms and wet conditions and those elevations go up, it's completely based on this projection that will be released in the next 2-week time period. And so it makes a big difference looking forward given the status of the reservoir elevations right now. This is, again, the trending diagram showing what the Lake Mead end-of-month elevations will be. I think we talked about last month, if we see this lower release pattern, it's going to drop Lake Mead 4 to 8 feet in the next year. So it'll put us that much closer to shortage triggers. The interesting thing here is to see that solid dark dotted line towards the bottom of the range. What this is showing us is the range of best water supply conditions and worst, and we're trending along the worst probabilities, not the best probabilities. So again, things are not looking good, they're not improving. I'm just putting this on here to remind us all of our obligations. You're familiar with these. Where this comes into play, again, is the Lake Mead elevations. And this is my last slide, but we talked about if we have this lower release, that the probability of shortage will increase significantly in the year 2016 and 2017. What we know pretty assuredly right now is if we see a lower release this year, it's going to really put us on notice for 2016. The consequence of a shortage for IID is not a reduction in volume, but it is a suspension of the overrun policy. So we would be put on a hard capped entitlement without the flexibility we currently enjoy. If we have 2 consecutive years of this lower release schedule, which is sort of the doomsday worst case scenario, but if we have 2 years in water year 14 and 15, you have almost 100% probability of a shortage in 2016. So we're hoping we don't go there, but I just wanted everybody to be aware of what's looming on the horizon if we don't see some wet supply conditions moving forward and what we need to be anticipating. I'm getting a lot of phone calls now. I should know next week, and it will probably be announced at the Colorado River Board meeting what that determination is. But the last couple runs they've done on the model, the hydrology is not improving and the inflow conditions are worsening in the upper basin. So we should kind of steel ourselves for a 748 release starting in October. And that's all I have if we have questions.
Okay, thank you, Tina. Any questions for Tina?
It's just very important we get our inadvertent overrun paid back before that hits.
All of these scenarios are contingent on us paying back in full the obligations as scheduled. So, there's different consequences to that. We are likely to see some action. Right now, we're hovering right on the forecasted projection for use to date, right at our annual entitlement. Also, as a reminder, I did receive yesterday via email from the Bureau an approved water order for 2013. So, it's 3/4 of the way into the year, but we did get our approved order based on what we requested. So you should see those numbers that are in red on the Bureau forecast turn black for a change.
Okay.
Director Desert, I have a
Benson?
question. Yeah, as far as the shortage conditions, I was trying to read the footnotes, but it was too small, even with my new glasses.
I can give you the crib sheet version.
The California doesn't take a shortage until it gets to what elevation? I was trying to see that.
I will come back to you hopefully in September with a more detailed shortage presentation. I haven't looked over those lately. The first, I think, 320,000 acre feet of shortage goes to Arizona and Nevada.
Footnote 6 on page 87 of our agenda. I don't know which it. I think it's 1,025 feet.
1075 is
1075 is the first shortage for other states. I think you're right, Steve. For California.
The first one's Arizona, and then Nevada starts getting cut, but they really don't get cut as fast as Arizona, it looks like.
There's some proportional cutbacks. Nevada only has an entitlement of 300,000 acre feet. Arizona's is 2.8 million acre feet. So
right.
you're going to see the volume
Okay, so it's
cutbacks
proportional to
Arizona.
both of them.
Yeah.
And
And
Cali-
then Mexico has a small amount they've agreed to during the 5-year period of 319 implementation.
Okay, because it's been asked to me, what's the impact of farming if there is a shortage condition, but I think we're far away from getting to a shortage on the IID.
You're going to have pressure.
The first hit's about 600,000, and that's Nevada and Arizona.
Right, and then it starting at the bottom and working up metropolitans on California, right?
We'll all be fighting at that point.
So I
But
guess
yes.
it raises a question of us as a board, what we need to be thinking about going forward. But, we've always asked for storage, and if there's ways we can conserve as a district, if there's a way that we can fight for storage on that river, it holds up the bathtub, if you will, and helps other people.
Right. As one of the larger water users, you have the most ability to affect the elevation in
Right.
Lake Mead. So there are actions this board could take that would keep that elevation higher than under normal circumstances. So we may have some folks that are friendlier to IID because of their wants moving forward. Not to say that they'll adore the things we do, but they may have self-interest to protect that may provide partnership opportunities.
Okay. Anything else for Tina? Thank you, Tina. Okay, and we're going to move next to information item 23, page 175 of the agenda. This is a review of the 2014 calendar year fallowing program solicitation process. Page 175. And welcome, David Bradshaw.
Thank you. My name is David Bradshaw. I'm one of the assistant managers for Water Department. And on page 175, I'm bringing to you our fallowing program. We're currently in a fallowing program now. For those of you that want an update on that, it's a July through June program. This is 2013 through 2014. And it's at $125 an acre foot. And we have 180,000 acre feet in that on 34,000 acres. And so the good news is that covers our 2013. But for 2014, we've got some payback water. We're looking at about 250,000 acre feet we need for 2014 calendar year. And typically we do a mid-year to match leases, and it would be almost double that. So the reason I'm here today is to propose doing another calendar year 2014 program. We did a calendar year 2013. Not many people signed up. We had less than 2,000 acres. It doesn't match leases, but at least it gets us some water. And we're looking at doing the early start option. If you hadn't had any water on the field, you could go up to 6 months ahead of time. The same rules as before on the 3 out of 5 years. If that's your maximum, if you've been in 3 years, you wouldn't be eligible for a fourth. And the revenue would be up to you, but we're recommending probably around the $125 an acre foot range. The San Diego part, they're going to be paying almost $600, $594 next year. And we're hoping that we get some sign-ups. We've had a few phone calls on our existing program saying, can we still sign up? But it's not overwhelming. The calendar years don't get a lot, but we really want to get a head start on this. So it's for your consideration. That next page on 176, that shows all of our programs, a little summary from 2003 till now, ending with that last one that I mentioned at our biggest program so far, 34,000 acres.
David, for what we're producing this year for 2013, are we going to be creating some extra conserved water that'll carry over for application purposes?
It looks close, but it'd be probably in the 5,000 acre foot range, but not much. Now, as far as the program, the 13-14 program we're in now, there's going to be half of that. There's 92,000 acre feet of that'll be carried over. So we have this 182,000 acre feet, roughly half of that we would have available. So that's counted in my 250,000 acre foot number. So
So it's above the 250. We have the 90.
In round numbers, you're going to need over about 300,000 acre feet, and we have the 92,000. So we're going to need quite a bit of water.
Now that says 375,000 acre feet. So we're getting we're counting 40,000 from on-farm.
That's right.
Year?
We our number does include up to 40,000, depending on how many people sign up for Darren's program. We could cover that with fallowing if we had to.
And then how much through the system do we typically receive?
It was supposed to be around 4,000 for the first year. I don't know what the exact number is, but it's those lower numbers because a lot of that system is monitoring and that kind of thing that you're not getting.
I thought the seepage recovery we get.
That's counted already. That's in the 32,000 acre foot.
Oh.
Yeah, and some of that would go to Coachella. So what's left after all that, and even some of the solar, is still needing over close to 250,000 acre feet.
Now, how much have you taken? How much credit have you taken for solar?
We're looking at right around 23,000 acre feet.
For 2013?
We don't have the exact number because we're still in 13, and we have to subtract out any water use that's used there.
Mr. President, if I can add to this, this item was brought up to the Water Conservation Advisory Board. If you remember that one meeting where in the end they didn't have a quorum, and so the concern had been before that we're going to that farm unit fallowing and there was talk about doing it beginning of the year, in other words, the same time that this is, but we're not going to quite be ready, and so they agreed that it was okay to go ahead and do this, and so then if we start the farm unit fallowing next July 1st, there would be two programs that would be different running concurrently the last 6 months. Unfortunately, again, they didn't have a quorum, and so they didn't vote for it, but the WCAB was in agreement with this proposal. And I don't know if Al is still here. He can maybe just verify that.
David, the 250,000 acre feet,
yes.
That includes the payback water for
Yes.
2014?
Yes, all the payback water. You're looking at 150,000 that's required for San Diego, another 150,000 of payback, and that's where you get to your 300, and then you can add on the on-farm would be the 40. And
David, could you take that schedule and then line it up with your fallowing and just send it to the board as far as looking forward, what you expect the fallowing acres to be?
Sure, it gets better. If we can get this payback paid back, things look a lot better, as you can see on that chart, even for 17 and 18.
Well, now, my understanding is that in 2017, the fallowing program ends. Is that correct?
Correct.
Per the QSA. Is that only on certain parts of the conserved water or the whole QSA?
I've always been told it's the whole QSA, but someone could probably answer it better than that for me.
Yeah, it's supposed to be for the whole QSA.
Okay.
Oh, sorry.
It's the only contractual prohibition is for the San Diego term. So there were other terms that were idealized to be efficiency, but the only contractual provision is in the San Diego transfer.
That San Diego,
it's a 15-year limitation, and it was focused on the salt and sea mitigation and minimizing the impacts to the sea for that period.
Okay.
So we're on for information, but I could answer any other questions. Hoping to come back sooner than later. The farmers want to know right away. I looked at last year. I was one day off. We got approval August 7th last year. We need to send out letters, let tenants know, let owners know, start that process. And so I'd be looking for your direction, maybe August 20th or
Actually, this item and the one to come are on today's agenda because I advised the board that in response to a question from you, Director Benson, when did we have to have our program together? And I told you by the end of summer. So September we have to reach decision points, and the feeling is that to not have a program in place in January would be too risky. So whether or not farm unit fallowing starts July 1, there will need to be some aggressive conservation program in place, primarily through fallowing. And at the WCAB meeting, the last one, Mr. Kalin volunteered to, since he was going to be here anyway, to call a meeting of WCAB. And I hope that can happen before the board next meets.
Okay, any other questions for David? Thank you, Mr. Bradshaw.
Welcome.
Next up, we're going to be handling information item 24, located on page 177 of the agenda. We're going to consider the following IID-owned western farmlands for the 2014 calendar year fallowing program.
Correct, and this is along that same vein, and this usually comes up every year. Our current program, our last direction from you was to fallow approximately a third of the land and work on some different leases there. This is a proposal for looking at all the land and then making a decision based on that. We have around 18,000 acre feet. These are rounded numbers. And 13,000 acre feet of that is leased and has a current water history.
13,000 acres.
Acres.
Oh, I'm sorry, 13,000 acres. That would yield 65,000 acre feet. And along the same line of getting water for our 250,000 acre feet, this would go a long way to help us there. This proposal would be, and it's up to you, but the recommendation would be to have the tenants continue paying their rent. And I know some of the rents are lower and some are higher. There's differences there. But they would get paid not the same rate, but it's $75 an acre foot for their water use. And the next page, you can see on page 178, it gives you an idea of what's eligible, what's ineligible. It'd have to meet all the same rules as our fallowing program. It'd have to have water the previous 3 years, have to be a certain size, have to have real wet water to be conserved. And so that's where I got the 13,000 acre figure.
And the 5 acre feet per acre, that's a historical use, or is that a
That
number?
was my number, just to put a number in there.
So we haven't looked at
It'll
the
be on historical, but it would be probably, my guess, just based on past history, 5 to 5.5.
I would recommend that we look at that fallowing program for the payback.
If I can add to this proposal, we don't say it here, but this would be voluntary, and so because we don't want to also put people out of business by forcing it upon them, and so even if we get half of the people participating, I think it'll still get us a reasonable amount of water that we can.
I think you'll get the participation, because that's a whole lot better than giving them zero like we've been giving them.
Right, and so and I'm assuming also, we didn't say it here, but that if we pay them this amount, and the ones that are participating now at no reimbursement, we would go back and pay them the same amount as well.
Now tell me, would this be a January to January program, or
Yes.
so this would start
Be
January
calendar year, because
2014?
our focus is to get water early.
For
in the year.
remember, this is for the payback specifically. So
And you're confident that the historical use is going to equal 65,000 acre foot?
Up to. Up to. Yeah.
Up to.
Yes, and that'd be a real number.
That's if all 13,000 is
Right.
enrolled.
Yeah, and we don't expect them all, Matt, because part of it is, and I have a line in here, consideration will be given to, some of the tenants that rely solely on that land, they would be exempt. You're not going to, if that's the only land they're farming, they would.
Would the Bermuda grass fields be looked at for consideration because of the
Yes.
perennial type nature?
Oh, sure.
But I'm also being told that Bermuda grass can be fallowed for a whole year, then they can water it back and continue to farm it.
I've
Yes.
heard that. Depends on the ground. We've seen a little bit of that.
Worship my house.
It's debatable though on what kind of a crop you really get.
it'll be up to them
Grass,
to
too.
decide if they want to participate or not. So.
Worship my house.
So what I was looking for is direction for us to go forward. If you would like this entertained, and we'd get real estate involved and ask them to look at it more lease by lease. I don't really have that information, but real estate would be able to look at it in more detail if you're interested in going this route.
Are you saying if someone's at the end of their lease term, a lot of these are 1-year leases, right?
Several of them are.
That we're going to give them, we're going to pay them to not farm ground that they're renting from us.
I'm not sure I understand the wording, but
They're going to
For
rent
1
ground
year.
from us, and we're going to pay them more than their rent.
yes.
To not
well,
farm.
Sometimes,
Right.
yeah, in some cases. I don't know all the rent rates. Rates.
I have a problem with that.
You don't have a problem with them having to fix the ditches that were shot?
not gonna do
and pull
anything
out
in that
the
year.
salt and cedar trees?
What
Yeah.
if we?
A
These
few years
people
ago-
still have upkeep of the ground.
If they're not making
because
money
the
doing
IID
it,
is
they
not
wouldn't be
good
doing
stewards
it.
of the ground whenever we follow it and we don't take care of it.
A few years ago, we did have some issues with that, and it was costing us quite a bit of money to go in and clean them up. So the idea was rent them out for almost whatever rate you can get, and get some water on those fields. This is before we had overruns too. Get some water on those fields, get some crops going, and get the land in better condition. And so we did have that push, and then we did have several 3-year leases. So this would hit with some of those. So some of them wouldn't be kick off the land; they'd still have their 2 years. But it would really be case by case. I don't want to speak for every lease that they've arranged, because it would have to be looked at case by case.
I think the thinking was that a modest inducement in order to generate more water in that big payback year, that the water would be more important than the
Well, the other
consideration.
issue is the ones that rent this ground, we have the right to go in there and use it for fouling whenever we need it.
Correct.
So, you know, I mean, it's not like, you know, they're getting such a good deal. Because we'll take it, give them 0, and then the next year they got to go in and clean it all up if they farm it, or 2 years.
That's correct.
We do want to maintain some type of tenant activity on the ground in the future.
It is expensive to get out there and clean that up otherwise, and the ditches too.
I would suggest that you go up there above Nyland, the ground that we took back from these growers, and we fouled, and go take a look at the growth that's in that field.
Okay.
Any other questions for Mr. Bradshaw on this?
Okay. Thank you.
Thank you. Tina, or Lindsay?
Quick question. Maybe I missed it, but was this a voluntary program or mandatory?
Yeah, it is voluntary program. And then we mentioned if that's the only land you farm, that you would be exempt from having to give your land up for this. It'd be case by case, but voluntary.
Yeah, I had a little bit concerned about crop loss, potential crop loss, but if it's voluntary, that's okay. I would suggest if the WCAB is meeting before your next meeting, that this issue be brought up for their information and consideration as well.
Sure.
Thanks.
Okay, information item 17, report on compliance related to soil fumigant VAPAM, page 94 of the agenda. Presenting today is Mr. Kemp.
Michael Kemp, Real Estate and Environmental Compliance. We're following up with you on the Federal Insecticide, Fungicide, and Rodenticide Act, easier said FIFRA. But in 2008, it captured metamsodium and methyl bromide and some other chemicals under its umbrella. And in so doing, they laid out a phased compliance program for these products. Their key issue was to separate them from handlers and to separate them from the public in general. It phased in 2010 and 2012, late or December of both years, so basically 11 and 13. In the 2012 phase in, the key issue was buffer zones. It was required that if you were going to use these products, then you had to provide a safety buffer zone around your application. And in so doing, if there was somebody inhabiting that zone or it was a public right-of-way, you had to get a permission letter or some sort of validation from that group or from that resident. We came across this early in February. The North End Water Department was approached with what we call an exclusion letter, which is we're going to set up a buffer zone, we're doing an application, and we don't want anybody in it. That was problematic for the operations group in water. So we brought that to you in April and said, okay, here's some of the issues. And to your credit, you erred on the side of the customer and said, go out there and see what we can do. Is there any way we can accommodate this? So in recruiting, I recruited legal and I recruited the Ag Commissioner's Office for support. And we approached EPA and the Department of Pesticide Regulation to look for opportunities where we could be in that space. We could occupy the buffer zone in some capacity or official capacity or as a non-handler. It took some time, but in June, EPA and the Department of Pesticide Regulations formally responded to us with there's no way to be in that buffer zone unless you're a certified handler and using some sort of respiratory device or a part of the application procedure. So having that information, I met with Jesse and the other water coordinators, and we went over what we had to work with, the opportunities we thought we had that, DPR and EPA basically said, we're not going to allow that. We're not going to give you an exemption, and we're not going to let you into that zone unless you're going to basically become a part of the application. Having that information and discussing it with water department, we reached out to, I know the water managers reached out to farmers they knew. Jesse talked to Farm Bureau. I took the Ag Commissioner's office. I talked to several of the applicators, and I think it's kind of the consensus opinion that the reason the EPA standards are in place is to basically phase out these products. So with that in mind, we've come to the conclusion that if the buffer zone captures our lateral or supply canal, we are not going to be able to accommodate that application. We're going to say no.
How long have they been using this product out there?
Years.
30 years.
And all of a sudden,
So we're going to get rid of the carrot industry and create more fallowing? You guys don't grow carrots anymore?
We
What are you hearing,
can
Mr. Director Benson?
make every effort to accommodate, but we don't think that we can support a buffer zone where we can't be in it. Our operations are in the buffer zone.
I'll defer to Mr. Kalin. I've rented him carrot ground, and we don't grow carrots, so I think that there is a new organic product coming out that they can sprinkle on. They don't know the effectiveness of it, but it does present a real issue.
Yeah, I think with both VAPAM and Telone probably coming next, there's nothing you can do. I mean, we're beating a dead horse. You can't change the federal EPA label. That's all there is to it. So as far as everybody's concerned, VAPAM is no longer something that you can use in the Imperial Valley.
so we just buy the carrots out of Mexico where they use it.
Well, there's a lot of organic carrots grown in the Imperial Valley, and they don't use VAPAM. So I think I know what we're doing is we're switching to Telone, which is injected into the soil. And we may be able to get away with that for a couple more years before EPA decides to change the regulations on that. But we're also, in the meantime, going to implement the same measures that the organic farmers use on some of our fields and see what the outcome is. It may be we don't need to use those products. We use the products that the organic farmers use. So that's where it is right now.
So the farmers, the industry is not going to come screaming at the IID about not getting water service?
Because this is a federal regulation. I mean, they determine what the label says for the manufacturer. You can't go to the Ag Commissioner and say, can we do it here? No, you're looking at a federal label, and so it ain't going to happen.
And everybody knows how much common sense the federal government has.
So as far as irrigators on those fields, the irrigation staff for the farmer has to be taught how to use it and wear the respirator. And have they been doing that already?
You mean for VAPAM?
For VAPAM, yeah.
Oh, definitely, yeah.
Okay, so could there be an instance where they're trained on how to operate their gate to open it for water delivery?
Yeah.
Do we have them operate our gates, our system inside
For that
buffer?
single occurrence of VAPAM? I'm just trying to think of ways outside the box where we can be accommodative.
That's a possibility, yes.
I've seen farmers run the laterals before on rainy days when the district didn't have a four-wheel drive, and the farmers would run the canals.
I've seen them run it at night, midnight.
I'll have to admit that I have done it myself when I find somebody stealing water up above me.
It's the moon effect, Al.
Yeah.
It's the moon causes that shortage.
So VAPAM's gone, and Telone will be the only way that these guys...
Yeah, and that'll probably be gone in the next couple of years.
Yeah, could we contract out with someone to have the respirator to go to these gates and set up a schedule?
You don't have to wear a respirator unless you're handling the material, you're actually...
But as far as entering that buffer zone, it sounded like you have to have the respirator.
No, it's not the respirator. What you have to do is have a training on how to, how you operate while that material is being applied.
I
don't know if that means you have to be on the farmer's payroll or anybody,
As an agency, we can't provide that training to our sand harrows that have already for 30 years been driving through those same buffer zones?
Sure. I'm sure the manufacturer, Dow Chemical, would be more than happy to provide the training and even feed them lunch if they could sell the product.
Yeah. I was just wondering if there's a third-party group, because I don't know that we want to submit employees to that hazard in the sense that then they develop a sneeze and come back, and
there's a test.
There's a lot of issues that we can have.
After the course, then you have to take a test, and you have to get 80%, or you don't get the certificate.
Okay.
Excuse me, in talking to Rockwood Chemical there, one of the issues that they're concerned that what liabilities they may have if they sell it. So I'm not sure that they're even going to make it available. I think it's like Al was saying, I think people are coming to the realization that the government, federal government, doesn't want you to use it, and it's just, they're kind of forcing the issue on that. So we were trying to do, for instance, if there was a right-of-way that we had in the drains, we were willing to sign that exclusion letter, but for instance, Rockwood, they just said, well, they didn't think it was worthwhile to even go that far. So I'm not sure that that we need to worry about the issues, Steve, that you talked about, because we looked at that too, and then we said, well, I think the liability is so great that probably Rockwood wouldn't even want to do it.
And they're the only provider right now, right, of vaping?
So.
Yeah.
But they're also providing the alternative that the organic farmers using.
Okay, Mr. Kemp, is that the rest of your presentation?
That is, I just wanted the board to acknowledge that we've made every effort to reach an accommodation, but I think we're at a point where our most likely answer will be no.
Yeah, I would say if there's some way to contract, just kind of pursue it a little bit.
And that'd be up to the applicators, and that's the way the code's written.
So if you talk with the commercial carrot growers, the Frank Riddles and others, have you communicated with them about what their plan of action is?
I spoke with Bolthouse, and they're going to find another product.
They're going to find another product. Okay, very good. Thank you, Mr. Kemp. Anything else for Mr. Kemp? Thank you. Next up is information item 19 is a review of change to policy number 7200, critical infrastructure protection standards, page 99 of the agenda. And presenting today is Mr. Tony Allegranza.
Good afternoon, Mr. President, directors. I'm before you today in my role as the SIP Senior Manager. This is the Critical Infrastructure Protection Policy, which requires a review by the Senior Manager every year. The purpose of this policy, it is the purpose of this policy and procedure to provide guidance, implementation, and authority in maintaining a secure critical infrastructure protection program. This policy describes Imperial Irrigation District management commitment to securing and protecting the critical cyber assets. The scope, this policy and procedure applies to all employees and contractors having physical and cyber access to assets critical to the district's reliable bulk electric system and operation. This does require review on an annual basis by the Senior Manager. It was last reviewed in December of 2012 by the previous Senior Manager, and there were only some slight modifications. One was the responsible department was changed from IT to the Energy Department. There was a reference added to the appendices, and in the appendices there were some minor clarifications and number corrections. We would just like to formalize these revisions to the policies through board approval at the next board meeting.
And Tony, does this have to do with how long we're going to retain our emails in our system?
No, this is not the document retention policy.
Okay. Any questions for Mr. Allegranza? We'll review this and look forward to seeing it come back as action.
Thank you.
Next up is information item 20, review of budget amendment related to reliability and compliance activities, page 162 of the agenda. I skipped? Sorry, Carl. Energy matters, the Energy Department General Managers,
It's okay.
Mr. Carl Stills.
We can skip my comments if you want.
That's okay.
Actually, what I would like to report is about 4 issues. We are going to be bringing to the board the affected system study on August the 20th. I think the board has requested that come back to you, so that will be here. And then our backfeed station service that I reported the CFO's office was working on, they've completed that analysis, and there will be a WebEx review for stakeholders on August 22nd at 10 a.m. I believe that's the date, Jamie. If the board members want to sit in on that, you're welcome to do so. The third thing is that we've had a team working on streamlining the CSP process, and this effort has been led by Tom King and Angela Evans and supported by Arn Lottie. And I'm happy to say that they were able to achieve what we told the board we wanted to achieve. They've realized about in excess of a 50% process gain where they've unburdened that process, and we're shortening CSP timeframes down from 10 days to 3 days. So there should be benefit to our customers out there in streamlined process in the meantime. And I've asked them to put this in a board presentation and bring it before this board, so we'll get that together for you. And the fourth item is that if you remember right before the summer, Rockwood GT Unit 1 in Brawley, the 25 megawatt gas turbine up there, we lost a unit breaker due to a fire. We had to take some emergency steps to bring in a temporary breaker and put that in place. That was returned to service full-time today, so that GT is back in service.
Is it under emergency breaker or under a replace breaker?
It's under the regular, it's back on.
We bought a new breaker?
Yeah.
What was the cost of the new breaker?
I'd have to go get that information.
Is that why they're hard to replace that overnight like that, because they're 92 kV or because of the age? Or
to get the material here, we actually had to lease a breaker, and to get the actual material here takes time frame. We actually paid for an expedited schedule.
So we manufacture the breaker, or did they ship us a new one?
I don't know if they've manufactured it. We did go out and get a new breaker for it.
Okay. Is that everything under energy?
That's everything under energy.
Any questions for Carl, board?
Now, can you give us a report where we're at with Grand Plaza?
I believe Vance was here. Actually, they paid $1.5 million today. If you remember right, we were looking at that contract, and we felt that we needed security, and the board authorized us to go put a contract in place. We were looking at some type of bonding. They decided that they would do some type of security rather than a bond, some letter of credit, something, and then they decided it would just be easier. So today we received $1.5 million to start purchasing and start moving that forward. Well, it was 1.9, so they've given us 1.5. So I got an email today that we got 1.5 on that, so we'll...
The security that that your board required, they've just gone ahead and paid.
On their own.
Yeah. And Vance Taylor's working on that. I think he expects to have... Oh, Vance.
Yes, I just got an email this morning from Sam Singh that said that they put down about $1.5 million. They went ahead and paid what they had previously requested be an extension of credit. There's still one of the customer service proposals that's not complete. It's expected to be complete later this week, but it looks like they're going to be paying cash for everything.
Are we going to be able to get the material they need in time?
Yes. Yes, we'll be expediting that process now that we have the money and the funds to move ahead with it.
Carl, I had a question before you step away. Sorry. How are we operating this summer as far as reliability? Have we had any problems or glitches with our system or with WEC or in the region?
Actually, our system reliability has been very good. We've had minor disturbances, but most of those have been explainable, and there's generally one-shot lockout trips, and they go back in. The system has held up very well. It doesn't mean we're out of the woods yet, because if you remember, September was when the trips happened 2 years ago, and then last year on September 25th, we had the major 500 kV line. But the real issue comes down to the amount of flows coming across the line. So our system's held up really well.
And are we moving more power, or is there more power going through us or around us now than there ever was?
Yeah, there's heavy inflows. You have to think that with the once-through cooling, they lost about 16,000 megawatts of generation. With the songs being out, they have to import that power and do something to replace that. With the water tables being down, they were 40% down on their hydro generation. That just says that they have to go out and bring energy in across the lines, and that's pretty heavy flows. Our concern was, had they lost one of those big lines, those flows were going somewhere. I think Jesse, our guys have been working, managing the system very well. Jesse, do you want to comment on that?
Yes, the flows on the 500 kV lines that pass through the south and the north of the system have been heavily loaded. We've actually extended our view. We've been working with the Cal ISO, and we have data now from the Cal ISO that we're actually monitoring. And last week we lost the one of the 500 kV lines went down, the Sunrise Power Link. It went down from Imperial Valley to Miguel, and we're monitoring. The guys were able to see what was happening, and it did not cause a disturbance on the system. So we continue to monitor. We're expanding the view of the operators that they have, not just on the IID system, but external elements that are critical to the reliability of the system. We're doing that now.
Okay, thanks.
Which tells you that the changes that we've made are actually beneficial. We're actually holding up fairly well when other people are struggling. So,
actually, on to that point, Carl's being modest but also careful. I tempted fate yesterday and remarked on how well we were doing so far this summer. He reminded me that there's August and September to go. So you know, I mean, you're in the dead of summer now, and the system's performing remarkably well.
But that goes to a lot of the changes, and I think, are you through? No, Vance. Oh.
So where has the majority of the power been coming from? Arizona, Texas?
Do you know where they're purchasing it from?
Because of the outage of songs, they're importing a lot from Arizona.
Okay.
Was that everything, Carl, from Energy Manager?
Oh, that was the Energy Manager's position.
You ready for the next item?
I'm ready for the next item.
Okay, information item 20, review of budget amendment related to reliability and compliance activities. Page 162 of the agenda, and presenting is Mr. Carl Stills.
The Energy Department has been looking at a lot of reliability issues, same thing we were just talking about. We've made some major modifications to our system operating center out there, things that have improved our operations quite a bit. In order to do that, there's operational expenditures that we're running into. Quite frankly, I'm looking at right now transferring dollars that we think we can transfer from the capital budget, about $5.2 million from capital over to O&M budget to accommodate the changes that we've made. So I'm asking the board to approve the transfer. If you'd like me to go through what we're cutting, I'd be happy to do that.
I guess the question is how critical are the items you're cutting, or are they maintenance type things you can delay for a year?
Now, they're lower priority projects. Take our S-Line project, where we're delaying the S-Line, the pole crossings out there because we can't take the S-Line out. So that project's going to push anyhow. The F-Line 161 upgrade, we had monies in the budget. Right now, that's on hold. We're not moving forward with that, so we're taking monies from that. We've got our Avenue 52 bridge grade, and I think you saw that the Irby contract, we had $400,000 for that. That's a schedule issue. We don't think we're going to be able to finish that before the end of the year. We're only going to be able to get about $400,000 of that. We want to take the other $700 over to here, and we'll re-budget that portion for the end of the year. We've got a Baus capacitor that's about from Baus sub on WAPA's system that's 30 miles north of Yuma. That came in actually less than, our portion of that was less than we had actually anticipated, so there's $200,000 there. And then we've got a series of distribution capital projects, most of them up in the Calipat Island area, and those are lower priority distribution projects that we feel that we can push out, move the dollars from those. And then we had actually brought in the backup control center and had money left over in the backup control center. We're asking to transfer those dollars over. That's $2.15 million.
So that's almost half of this money is coming from that reserves?
Yeah.
From the backup.
Yeah, so the backup control center is now in place. We now know what the reserves are, what we can move, what we don't. And then if you remember right, the telecom project that was originally budgeted at 75-25, and the board voted to move it back to 50-50 in the budget. That freed up some dollars that we're also transferring in this process. So we're asking that those total up to $5.2 million or $5.192,500. We're asking the board to approve that transfer from the capital over to the O&M so that we can have the funds in their O&M budget to pay for necessary expenditures.
I'd just say bring it back next meeting.
Any other questions for Carl on this item? Thank you, Mr. Stills. Information item 21, update on regulatory monitoring activities by the Energy Department staff related to FERC orders 764, 1000, and 1000A. Page 164 of the agenda, and presenting today is Mr. Noe Gutierrez.
Good afternoon. My name is Noe Gutierrez. I am the interim regulatory and policy officer, and I am going to be speaking today about the Federal Energy Regulatory Commission Order 1000, 1008. I'm going to touch a little bit on 764, FERC Order 764, and the current energy imbalance market. So for the agenda again, we talk about FERC Order 1000, FERC Order 1008, a little bit of description and highlights. What are the challenges of those two orders, which pretty much are cost allocation, the schedule, and decreased workload for everybody. And again, FERC Order 764 and the publicly owned utilities, PUC EIM, which is Public Utilities Commission Energy Imbalance Market, which is being very pushed or embraced by the California Independent System Operator. So first of all, FERC Order 1000 was issued in July 11, 2011, and it's about regional and interregional planning. The intent of FERC is to ensure that FERC jurisdictionals are provided with the opportunity of just and reasonable participation on transmission development. They want to make sure that there's not unduly discriminatory or preferential treatment on anybody that is just a transmission owner. I'll talk a little bit in the next slide about the new sectors that are going to be part of this transmission planning. So pretty much has to do with new principles developed for the rules of engagement on transmission planning. Pretty much talks about coordination, openness, transparency, information exchange, comparability, dispute resolution, regional participation, economic planning studies, and cost allocation for new projects. Pretty much that has to be on the regional and at the interregional level on the transmission from now on. One of the things is that anybody that has transmission planning and load-serving elements must designate which region they belong to. In our case, IID could be under the Cal ISO or could be under the West Connect. We have been dealing with West Connect. So my recommendation still is going to be that we stay there. And again, the new sector that I was talking about that is in the news in the next slide is going to have voting rights. And that is a concern. In the past, it was just anybody with transmission serving load serving obligation, which is the regional membership. But now we have transmission customers. We also have transmission independent developers and owners, state regulatory commissions, and key interest group like anybody that is pushing for renewables or like the Sierra Club. People like that has also a say in all this planning. Now, the cost allocation for new projects under FERC Quarter 1000 is mandated for all regional group participants. Now, the West Connect is one of the 4 regions that are part of the WECC. West Connect is considered a region that is composed by utility companies that provide transmission. It's about 18 utilities. 7 of those 18 utilities are jurisdictional, FERC jurisdictional, and 11 of those utilities are non-jurisdictionals like IID. One of the challenges for West Connect is that starting January 1st, 2014, this new planning process needs to be up and running. And of course, for that to happen is that we need to have participation agreements among the different members of West Connect, which is the 18 that I was talking about. And we need to modify our current business practice manuals so things that FERC order was promoting are reflected in those business practice manuals. And the other thing that we need to have is resolve the concern that jurisdictionals and non-jurisdictionals have right now. Non-jurisdictionals like IID have the authority to resolve any of this proposed cost allocation in the board. If we were to sign like anybody else, we will lose that. We're going to have to make changes anyway for our open access emission tariff, but we are following this to make sure that any changes that we do are something we can live with. What are the challenges for IID? Well, number one is loss of governance. It's one of the things that up to this point, we always decided what we wanted to do in our balancing authority. Now we have 4 different groups that are going to be part of this decision, that are going to challenge, that are going to comment, and they want to be part of the transmission planning and construction in the Imperial Valley. Now we're going to need more effort in whatever is on planning and economic analysis for this transmission, on these transmission projects. And of course, it's going to require more participation from IID in all kinds of WEC steering committees, working groups, task forces, and of course, we're going to need more participation in coordination and communication with federal, state, and local agencies. So for IID, it means a lot of work, more resources developed and devoted to this FERC Quarter 1000 and anything that will bring the FERC Quarter 1000. Now, I said FERC Quarter 1000, 1000A. FERC Order 1000A was issued on May 17, 2012, and the goal was just rehearing and clarification of FERC Order 1000. So pretty much what happened there is that we have 4 planning regions, which is the West Connect, California Independent System Operator, the Columbia Grid, and the Northern Tier Transmission Group. And what it's asking is also that the regional planning goes to the interregional level. All the concerns and things that FERC Order 1000 wanted to address at the regional level, take it to the interregional level. Now, FERC Order 764 is what is called the intra-hour 15-minute scheduling. And that was created with the intent of renewable integration. As we talked before, integration of renewables is a big challenge. CalISO especially is having a lot of problems integrating 12,000 megawatts of capacity on wind and solar. And what they think is that developing an energy imbalance market where a big footprint can participate with resources would bring stability to the system. You want to sell your resources, anything that you're not using, any excess transmission capacity that you might have, you can sell it to the CalISO. And this will help the stability of the system and would avoid the curtailment of wind in the Northwest and the North, and all those states that there's a lot of wind. So it's right now there are a lot of meetings and comments, and they're doing the third review of the third version of the straw proposal. They're thinking on having the last comments on August the 20th. And by November the 8th, they're seeking board approval, CalISO board approval. They have a memorandum of understanding with Columbia Grid right now to do this experiment. And there are, we think, might be opportunities for people like IID and Arizona, but we're not sure yet. Because this might mean that CalISO, for you to participate with them, you might have to let them almost run your system. Because it's 5 minutes. Every 5 minutes, they make adjustments to the system. So they need to have a signal and somehow play with the signal to dispatch resources.
Let me address that a little bit, because we're looking with this big market that's developing out there, and we think that if we can change our business rules, and you heard some of that today, if we can change our business rules and we can optimize our generation assets out there where we could potentially sell into this market, we intend to do so because we think there can be a huge revenue stream. What we don't want to do is give up control of our generation to the CalISO by giving them control of our AGC, or automatic gain control of our units out there. So most of the agencies that are out there are pushing back on that issue, and they're not wanting to give up that AGC control. But now the ISO has a problem because they have this huge imbalance, that famous duck curve that you've heard so much about. They have to have the energy. It's going to be a critical issue. It could be it's an emerging market that we're looking at taking advantage of, and yet it's the control issue that becomes the problem. So as a balancing authority, we want to sell into the market if we can to create a revenue stream, but we don't want to give up control of our generation.
Yes, and one of the challenges also is, number one, the control software. What kind of software they're going to use. Governance is another big issue. There's a lot of people that don't want to have California having, or the CalISO, total control on what kind of decisions they make on this energy balance market. The other thing is loss of independence that as Carl said. Now, there's been a lot of studies from the National Renewable Energy Laboratories that point in different types of benefits and disbenefits of doing this. Still working on that, a lot of discussion again. So it's more to come.
Hey, one more thing on the EIM. The other thing that we're cognizant of, and most of you have been aware that there was a push in California to have a single BA, a single balancing authority. EIM, the way it's presently being looked at and being structured, is an intermediate step to getting to that point, and everybody's really reluctant. If you don't want to be part of the CalISO, You want to make sure that you're not committing your assets into another agency's balancing authority. So it's a little bit of a balance on just the strategy of how we approach that.
Yes, thanks, Carl. So this is where we're. If I may, I'll go back a little bit on the FERC Order 764. I like to say where IID is. This is the 15-minute inter-hour scheduling. Right now, it's an option. We are requested to have it as an option. And that also requires from the people that wants to have the 15-minute inter-hour scheduling that they also do weather forecast and all kinds of things that pretty much at this point nobody has the capability of doing, neither the generators nor IID. But IID could do it. I checked with System Ops today, and it seems like we could do it if we wanted. It's just that we're still exploring anything that needs to be done for that, and if anybody wants it. So IID is okay on this issue, and we'll keep working on any requests that we might have from the public. With this, I will finish my presentation, and if anybody has any questions that I can try to answer.
I have a question. On FERC Order 1000A, who made the decision to go to West Connect? I'm not saying it's good or bad, but was there a pro and con for picking one of these regional transmission groups?
The other option that IID has is ISO.
So it's whoever's adjacent to you, pretty much?
Yes, we're geographically in the middle of both. The best bet for IID at this point is West Connect.
But who made that decision? Was that staff, or did it ever come to the board?
No, staff. Yeah, we go back like 4 years back at least.
So yes. what when you join a transmission group, what costs are you allocating? Any new costs or old costs? And how does that work?
I believe what they're looking for is any new transmission costs that are there. If they can determine that you have some benefit of that transmission cost, and they can allocate a portion of that cost to you. The problem is that you may not have any input into whether you have benefit or not. It may be somebody else making the case that you do have benefit. The interregional transmission is the issue right now. And again, they're trying to get the regional stuff, which we should have control of without that cost allocation. But it's the interregional transmission that's a concern for us right now.
So on the study design side, can they, now that we're part of West Connect, can West Connect say we want to put a line through the center of IID, and so be it?
Well, I think we're a part of West Connect, but I don't think we're completely a part of West Connect's planning committee right now.
But by January 1st, we will be.
At some point, we're going to have to commit one way or the other. And so what we need to do is look and see where it's most beneficial to IID to be involved with. And right now, it appears to be West Connect, but that decision hasn't been made yet.
What are the challenges of the two as far as West Connect versus Cal ISO? Cal ISO doesn't have generation. They're just inputting all the power, right?
Yes.
And then the West Connect, they're the ones with all the generation?
Yes. West Connect is like a bunch of IIDs with the same needs. We're not an independent system operator. It's Arizona Public Services, SRP, Salt River Project, El Paso Electric, Tucson Electric Power, LADWP, SMUD. It's just people with the same needs that IID has. Pretty much everybody is trying to stay away from the Cal ISO.
Now, correct me if I'm wrong, Noe, but the way that I interpret that is a non-jurisdictional is not forced into an RTO regional planning group. However, they're trying to make a rule that if you don't belong to a regional planning group, that you don't get the benefit of using transmission coming from that planning group. Is that
we're going to have to get some flavor of that. We cannot just be an island and not participate. Somehow, we're working with our FERC attorneys and, of course, the team, which is my boss, Jamie, Carl, and anybody that we can talk to and other public utilities to see what is the best thing we could do to protect our balancing authority. That's pretty much where our concern is, protecting our balancing authority and not be cost allocated on something that is not beneficial for IID. takes a lot of participation and a lot of discussions, but we are there. Any other question?
Any other questions from the board, from the public?
I just have a comment that I think that there was a period of time when there was quite a bit of talk about the possibility of IID joining the CalISO.
Mm-hmm.
And at that time, I wasn't really aware of what it would mean. I think I'm quite aware of it now, and it may have a lot of benefits, but it would also mean very much higher rates for the ratepayers. So that's where I stand on that position at this time.
Thank you.
There's one more issue on that. It's not only the cost. Imperial Valley is in a critical temperature zone. I mean, with the temperatures that we have down here, if we have outages, then there are life or death decisions for the public down here. Mm-hmm. The last thing that we want to have happen is for us to be a lower priority, to be placed back in service and have an extended outage time where that we could control ourselves. So to give up that control is something that, I just don't think we should do.
Right.
Thank you, Noe.
Thank you.
Jesse, did you have a comment? Oh, okay. All right, we'll move on to item 25, update on the water transfer, the IBank loan guarantee. Mr. Greg Brokey.
This is an update from my last presentation, which I think was in March of this year. Since then, we've conducted interviews for our investment banking team, and the staff has selected a team subject to board approval. Goldman Sachs is going to be the senior manager, and we have 3 co-managers, Citi, JP Morgan, and Wells Fargo. We asked the IBank if they wanted to sit in those interviews, and they declined, although they did provide us some input on the RFP that went out to all those firms. So the next step in the guarantee is identifying projects and developing a plan to fund those projects. Talking with water department personnel over the last couple of weeks, because we have spent some of the $50 million that the Water Authority has given us. We'll more than likely need to spend most or all of that before we need to borrow money. So it could be 2015 before we will be in the market to borrow any money. And then over the next few weeks, I do plan on meeting with external counsel to go over the details of the IBank, of the IBank guarantee, so that they can become familiar with that.
That's your QSA litigation counsel, Director Hanks.
Yes. Okay. Greg, on the amount that was available, was that $2,003?
It is in the contract as $2,003. It's $150 million of net proceeds, and we've estimated that to be roughly $217 million in 2013 dollars.
Okay.
And I should add one other thing. The IBank guarantee is for water system conservation projects only. They will not guarantee on-farm conservation.
Okay, and let me ask you this. Once you start processing, how long do you think it'd take before you could receive the funds?
Well, that's a good question, because everything that we is done, we're going to have to get IBank approval, and so we don't really know how long that's going to take. But one thing we're going to do to hope to help shorten that period is invite iBank staff to attend most of the meetings, attend all the meetings and be involved in the whole process so they understand what we're doing, so that hopefully they can inform their board along the way as what's transpiring. So when we finally get to the point where we need their guarantee, it's not a big surprise to the iBank board.
Can you just describe quickly what the iBank is, who it is, and what other projects that they typically guarantee?
It's the California Infrastructure and Economic Development Bank. It was created in 1994 to finance public infrastructure and private development. So it has broad authority to issue tax-exempt and taxable bonds, provide financing to public agencies, provide credit enhancements, acquire or lease facilities, and leverage state and federal funds. But I can't tell you. I have to do some research to find out what projects they've specifically guaranteed.
And besides the guarantee, what benefit is it to the ID? It'll be a lower loan rate when we go out to borrow money?
That's actually debatable, although the state did get upgraded today, I saw. When this process first started, the state had a higher credit rating than the district did. Now it's flipped. The district has a higher credit rating than the state. So the guarantee could end up costing us a higher interest rate. We won't know until we get to that point where we have to issue the bonds and price them.
So it's just a secondary, it's a backup to the ID paying, right?
It is, yes.
So why wouldn't you just sit on the IID's credit rating for that bond issuance?
Because the IID is not responsible if something happens to the agreement. Where if the agreement is terminated there's about 3 different reasons. The first year of debt service would be paid by the debt service reserve fund. The district is only on the hook for that second year of debt service, and after that the state. So that's why they're relying on the state's credit, and I think I'm probably not using the right term, but it's not a revenue guarantee. It's and the term is passed me by right now. But the guarantee that the market will look at will be lower than the state's normal GO or credit rating. Mm-hmm. So it'll be 2 or 3 levels below that.
I encourage you to keep moving on it, because once we talk with the attorneys, we need to expedite some of this system.
Well, once the projects get identified and I know when the money is going to be needed, we're ready to go. We have the investment banking team in place, so once the projects are identified, we can start the process.
Okay. Any other questions for Greg?
Is it a time-sensitive issue with the iBank, or is it a permanent obligation they have until we hit that proceeds amount?
It is. There's no deadline on when we have to obtain the guarantee. We can.
Okay.
Yeah, when we first started, though, it wasn't. Let's put it this way: they couldn't have covered the amount that was specified in the QSA when we first started dealing with them. When you first started talking with them, I think they've built it up since then.
Well, they have set aside about $24 million in a reserve fund, so that they have a little over $24 million. So if this does come to play, we get the guarantee and something happens and they have to make good on it, it'll be several years before they would have to go to the legislature to ask for an appropriation.
And
you're thinking back to when there was some confusion about whether or not $24 million was their total exposure.
Right.
Yeah, Greg has gotten past that.
Yeah, that's just the start.
Right.
That's not the total amount.
But I think it would be an advantage to this board to know all the circumstances and
sure
what triggers a guarantee or what doesn't.
Mr. Gualco will be here when you meet in special session next week, and he was around at the time. He was helpful back when Greg was investigating.
He was
this.
extremely helpful in pushing through the legislation.
So that guarantee comes into play when there's something goes wrong with the QSA, or
Yes.
Yes.
when the water doesn't get transferred anymore, essentially?
There's some interruption.
Either in our savings or on the transfer side?
It stops.
Okay.
That was one of the reasons in our discussion we talked about the system and to use the iBank and any other revenue that we have that would continue to be stable. So if something happened with the QSA, it wouldn't go back and impact the rates of the growers. Okay, thank you, Greg. Item 26, vehicle auction, Mr. Campbell.
Good evening. Don Campbell from Fleet Services, and basically what you have before you is just information that we actually brought before the board and got approval to declare these vehicles as surplus and sell them. And as is noted in there, we've already had one auction. We're scheduling another auction on August the 19th, and then December, January, we're looking at having another auction to get rid of the 10 remaining vehicles and the ones we're in the process of replacing right now.
Okay. Any questions for Don?
Are there any good trucks in there?
They're all good.
With our maintenance, they'll be good for another few rounds.
All right.
Jesse, did we miss you?
That's all right. I don't mind being missed.
Okay.
Don, someone asked me a question. Are any of these diesels, or are they all gasoline?
No, these are all gas. The majority of these are half-ton
Okay.
pickups.
Okay, thanks.
We want to give you that chance, Jesse. Do you have anything you want to add?
No, just I think if you notice on our water projections for the year, we're about right at
Thanks.
even. So we'll see how well we do. It'd be about another month in September before I'd like to look at it again before we can really know whether we're heading in the right direction or not.
Okay.
Just on that note, the trends, if you look at the last 5 or 6 years, they always seem to fall off the last 6 months of the year, except for the overrun years. and I don't know if that has to do with fallowing, but I'd like you to take a look at how fallowing played into that, kind of the acre feet that we took credit for, because a lot of people have asked that question. I mean, how could we have such a big overrun, which just happened to coincide with a year where we had big fallowing, and they just happened to be about the same number. And I mean, I know it's very coincidental, but some of that with the 6-month early sign-ups and
we can take a look at that. I think, and as you know, I look at the price of commodities as well, because it has a lot of effect on not maybe just the total acreage farm, but the intensity of farming, and so we have to look at that as well. We'll try to come up with something for you.
Right. Okay. Thanks.
This meeting's adjourned.